the authors of Section 230 in 1996, understandably and unavoidably failing to understand how the law they wrote would work in a future they could not possibly have foreseen. That is what it is. But what happens is you now have the federal government hiding behind the protections of private corporations who have this pair of provisions that make them into this unbeatable force, a force with all of the immunities and none of the costs, right? And this is reminiscent, I would say, of what we discovered through largely through Snowden, right? That, we have a constitution that protects us from the overreach of our government, but nobody thought to prevent our government from subcontracting, spying on its citizens to another government, right? In other words, I'm protected from the federal government spying on me by provisions that were written long before the modern technological era, but I'm not protected from the British government spying on me. And if the US government says, hey, spy on Brett to the British government, right? This is just unforeseen, right? So that Five Eyes, outsourcing of obviously unconstitutional activities is now happening in the context of social media, where the federal government, which is not allowed to censor me, is now telling Twitter and YouTube, here are the people that we don't want to have access to the world. You have Biden stepping onto a blood red stage and invoking clear and present danger, which is effectively a thinly veiled argument that the censorship is required for the protection of the nation. And this is, it's a nightmare. And so this is not a small matter that rests on the question of whether or not Section 230 should be two isolated provisions that provide benefits without the obvious cost that should go with them. This is something on which the functioning of civilization depends.
Yeah, no, I think you're right. And I do think this is a good time, I think, maybe to transition to talk about the cases that are going on right now, or the main case, which is the states of Missouri and Louisiana suing all the federal agencies that are involved in the censorship for this. And there is a doctrine under the First Amendment that recognizes under certain circumstances when the government is acting in conjunction with a private entity to censor speech, that private entity's speech, that private entity censorship can violate the First Amendment. And so what the state of Missouri and Louisiana are arguing is that the federal government has entered some type of partnership with the social media companies. They've adopted Section 230, which gives these social media companies this massive power to censor. And then they're working in conjunction with those companies to tell them what to censor. And the courts have recognized a couple ways that this can happen. One of them is when the government, compels private entities to engage in censorship. And here, a recent case dealt with the NRA in New York, where the NRA was offering these insurance packages through private insurance companies that would basically give you some type of protection if you're sued for firing your gun. And the state regulators and the governor basically pressured, saying, hey, we regulate all of you insurance companies, and we're going to start cracking down on you with our regulations if you stay in partnership with the NRA. And therefore, all the insurance companies stopped working with the NRA. And the court held that that was an example of suppressing the NRA's gun advocacy by pressuring their partners to not work with them. And therefore, that did violate the NRA's First Amendment rights. And so that was the compulsion. The second way that it can happen is if there's a partnership, if the government enters into a partnership with private entities to enter into a censorship regime. And that's what the state of Missouri and Louisiana are arguing. And they're saying, so the federal government has given this great censorship tool of Section 230, and then are partnering with these social media companies to tell them what to censor. And they've gotten through discovery and through some of the documents that came out in the earlier lawsuits by individuals, they've gotten a certain amount of documents that have shown this level of coordination and partnering. And they've gotten past the first hurdle that they wanted to. So they're seeking a preliminary injunction to basically tell the government to stop telling social media companies who to censor. And in order to get that, they need discovery. And so the lawsuit faced a first test, and back in July, the lawsuit got past that test. The court basically said, you have enough actual evidence of this partnership that if we assume it's all true, would state a First Amendment violation. So we're going to allow you to get this discovery. And then, so they've gotten a certain level of discovery. Then just yesterday, the court ruled that they should be able to get broader discovery, including people in the White House and Anthony Fauci and his communications with the social media companies. So there's more to come on that. And so we're really going to be able to dig into the evidence and see how deep this partnership runs. And if it is what we think it is, then that will end up being a violation of the First Amendment.
Yes, although I believe we have the evidence to detect an arms race of sorts here. And I do think the courts are the most likely. They are the entity, the governmental entity that retains the most public spiritedness and immunity from capture, such that they might still be able to function. But the problem really is, if you listen to what is said, no, maybe I should step back one step. The reason that we have the constitutional protections that we have is that the American founders, having experienced tyranny in their own time from the crown, understood the ferocious power of government and sought to explicitly limit it to protect citizens. The government has now, in many regards, I would argue in most regards, been captured by private interests that are not public spirited. Now, the power of government is tremendous. Captured, it becomes an asymmetrical weapon that functions on behalf of its captors. But even worse, like a child engaged in the question of, well, you know, if you had 3 wishes, what would you wish for? Well, wish number 1, I want more wishes. Those who have captured this ferociously powerful entity we call the government are not content with the limits placed on it by the Constitution. And so, because the Constitution is understood not to be a suicide pact, that is to say, even the provisions in it are understood in some contexts to be flexible, they are using certain terms and tropes to trigger the removal of ordinary limits. Right now, this is particularly egregious in the case of the term terrorism. Just like clear and present danger, the invocation of the concept of terrorism triggers many post 9/11 provisions that effectively unhook constitutional rights. So when the Department of Homeland Security, for example, declares that there are 3 kinds of terrorism involved in social media traffic. You've got dis, and malinformation. Misinformation being errors, disinformation being intentional errors, and malinformation being truth, which causes distrust in government. They are saying something preposterous and laughable, right? Truth that causes you to distrust your government is terrorism. Like, I'm not allowed to talk about the fact that my government has been captured. That's obviously nuts, but that's not the important part of it. The fact that it's funny hides the fact that it also has a legal implication, which is that all sorts of provisions in which the executive branch on its own authority can designate people as terrorists, and that once that has been done, the necessity to defeat terrorists is so great that we must avail ourselves of exotic rights to censor, to monitor, to corral, etc. That logically absurd chain means that we don't know what it is that has been said. And frankly, the right of discovery that the court grants only goes so far once the executive branch has behind the scenes said that because so-and-so said such and such, they are guilty of malinformation terrorism and are therefore a threat to the blah, 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 blah. Once they make that leap, even if a court would laugh at it, were that court to see it, there's no provision, there's no mechanism to know it's happened. You can't challenge it. There's no way to ask a court to review it. And so my basic point, and I know this has been long-winded, but my basic point is they have built a structure where if they can trigger a certain pathway, it unhooks all of the normal protections. And there's no way to even know it's happened. So as much as the courts may be our best hope, I'm not convinced they have access to the information they would need.